Welcome everyone to our Brooks Pierce end of year labor and employment year in review webinar. We're really excited to have you. There's a lot to cover today. My name is Brian Starrett. I am one of, as you'll see here, an august and fulsome group of labor and employment attorneys here at Brooks Pierce. We cover all aspects of labor and employment law. Try to keep our finger directly on the pulse of what's happening to try to keep you directly updated and informed on what matters for you and your companies and your businesses. So we've got a lot to share with you today. Not everyone on this slide is here with us, but many are. So we're excited to have you. We wouldn't be good lawyers if we didn't start with a disclaimer. We're here to share some news and some updates for you. None of this is specific legal advice to you. Of course, that's what we can do for you, but that's not the purpose of this specific webinar. This is informational for you. But to give you a sense of where we're headed and what we're going to cover today, we'll start with an update on reverse discrimination claims. This has a lot of its genesis in a case you may have heard about called Students for Fair Admissions. And boy, what does that do to DEI initiatives and related matters? We'll also give you some updates on EEOC activity. What are they caring about? What are they focused on? Where are they putting their resources? Because I think we can glean a lot from that for you. We'll then turn to talking about employee misclassification. Now, it's a familiar and repeated issue that is regularly top of mind, and feels like every other year or so we have fits and starts over what those rules are going to look like. So that's our sort of agenda today. The agenda here on the screen says we'll close with Q&A. I certainly encourage you, if you have a question during a particular session, go ahead and put it in the chat. I'm going to serve as sort of our traffic cop today to try to keep my eye on those and make sure I'm looking out for your questions and that they get to the right person to answer it during today's time. So while you're welcome to hold questions till the end, don't feel like you need to if something is on your mind that you'd like to ask while we're moving through the session. So with that, I'm going to hush and turn it over to my friend and colleague, Lauren Hoffman. Lauren.
Thanks, Brian. Good afternoon, everyone. My name is Lauren Hoffman. I'm here with my colleague, Elizabeth Troutman, to give a 15-minute update on reverse discrimination. And so, like Brian said, our initial focus is going to be that 2023 Students for Fair Admissions case and how that decision has influenced related shifts in the executive branch policy, particularly on DEI. Our goal for this session is to translate this environment into some kind of actionable guidance. Next slide, please. Oh, there's Elizabeth and myself. So, with the Students for Fair Admissions case, before this case, there was always a lingering question or issue of whether it was appropriate to consider someone's race as a deciding factor, whether that's in employment or whether that's in college admissions. So, in the college admissions context, prior to this case, the answer was yes. For college admissions, it was appropriate to consider race alone as a deciding factor, particularly as colleges had an interest in promoting a diverse student body. But this 2023 case changed that and changed the affirmative action college landscape as we knew it. So, among other holdings, the Supreme Court held that for college admissions, decisions should not be based solely upon a person's race. You could consider how race impacted that person's personal experience, but the person's race itself couldn't be used as a preference or a decision maker. So, for example, for my admissions to the University of Tennessee or Vanderbilt, they could consider my experience as a Black woman, but could not consider Black as a preference or a decision maker either way. So, another key takeaway here is that the idea of promoting diversity was not a compelling enough reason for the court to consider race alone in admissions. So, after this case, there was kind of this nationwide reassessment of how race appears in similar processes, of course, as we see in the workforce. And so, as we go along this presentation, we're going to look at how this case has impacted executive policy and how employers can respond. Just kind of an overview, the Trump administration has taken this case and stretched it beyond college admissions and has taken it to mean what you all probably have heard of as illegal DEI. And so we're going to work to define what that means. And so on the next slide here, we're going to discuss what we've probably seen the executive orders, but before we get into detail on those executive orders, we're going to discuss what executive orders are. So executive orders can't change statutes, they don't change Title VII, they don't change discrimination laws, and they also don't create legally enforceable rights. So an employee can't go into court holding an executive order and try to enforce some rights for local officials how to act. But importantly, what these executive orders do is if there is, particularly for federal contractors or a federal grant recipients, there is a heightened direct scrutiny of DEI practices. And even those who are not directly interacting with the federal government, there still is an impact because there is a shift in agency focus, particularly the EEOC. So, in other words, practices or groups or activities that may have been considered permissible under previous administration are going to be more scrutinized under this administration because of these executive orders and the policy shifts that they kind of formalize. And so, next slide, please. Looking at these executive orders in more high-level detail, generally these orders frame DEI efforts as unlawful, but they don't actually define what DEI is or DEIA, which some of you may have heard of. That's diversity, equity, inclusion, and accessibility. No definitions for what that means, so it's still kind of up to interpretation. Additionally, these executive orders task the Attorney General to create a full-scale plan to encourage the private sector to eliminate any DEI efforts completely. As I mentioned earlier, federal grant recipients, there's now a certification requirement of any DEI programs. If they have any DEI programs, you must certify that there's compliance with anti-discrimination laws. And so overall, when you review these executive orders that came out kind of at the beginning of the presidency, there are some really sweeping statements about legal DEI, but they don't really give practical context for what that means. And so we're going to go to the next slide and look at the July 2025 DOJ memo. So this gives a little bit more practical context. Again, this came out in the summer of this year, and this memo is technically focused on federal funding recipients, but it does guide employers more broadly on some best practices and how to avoid this illegal DEI. Now, a reminder that this memo is guidance, the executive orders, neither of them are law, but it does show the direction in which policy is shifting. And so, a general overview for what this memo and this guidance says is opportunities need to be open to everyone rather than being tied to a protected characteristic or racial identity. So, just to kind of highlight some activities that may be considered impermissible or under greater scrutiny under this administration, it would be things like programs that favor or exclude people based on their race. So certain leadership pipelines or scholarships or fellowships may be under further scrutiny. Additionally, with hiring, if there's a prioritization of a candidate because they're just simply because they're from an underrepresented group, that would be under further scrutiny, likely would be considered impermissible. And then kind of moving from hiring into the office, if we have segregated trainings, affinity groups, race-specific spaces, even when those spaces are supportive or voluntary for people to join, again, with this memo, there's a suggestion that these are impermissible under the view of this administration. So overall, this memo is helpful to review. It does give some practical examples, and it does help paint a better picture of what the executive orders are saying and helps explain that these executive orders are not as sweeping as they may initially suggest. And so next, Elizabeth Troutman is going to take it away and talk about some case law decisions that follow the SFFA decision.
Thanks, Lauren, and thanks for that sort of summary. I think what's helpful to think about is we as employers are operating in a little bit of a liminal space in that we have this Supreme Court opinion that says race can never be considered in making a particular decision. And that's always been an issue with hiring or promoting. Race cannot be a factor in an employment decision. And it also says that diversity is not something that justifies use of race in a decision. And then we have the executive branch interpreting that to mean that all DEI efforts are illegal. Um, and it's not really what Students for Fair Admission says, but some DEI efforts may be illegal under Students for Fair Admissions. So we're in this sort of middle space, and I do think that as you look at your DEI programming, it's worth contacting an attorney to think about, how are we going to structure this if you're going to continue to offer those types of programs? Because Title VII still requires that you create an environment where all people from all races are welcome. So, you kind of have these different mandates. And so I'm going to walk through a couple cases that are helpful just as we see how this is playing out in Students for Fair Admissions on particular questions you might have. So first up are two cases that I think are helpful just in thinking about the employment decisions themselves. So hiring, promoting, termination. The first is the Ames case, which is a 2025 Supreme Court case. And you can see how it sort of takes Students for Fair Admissions in the employment context. This was a case with um, where a white female who was heterosexual claimed she was discriminated against based on her race and her sexual orientation. So she was in the majority groups, meaning she was white and heterosexual. And in some circuits, the courts had held that you had to prove specific circumstances if you were not in a minority, right, to prove that you were being discriminated against. And the Supreme Court has now held, no, that's not the case. If you are being discriminated against based on race, there's no special circumstance. It's the same standard regardless of what race you are or if you're in the majority or minority group. Um, and you can see how that would make sense under Students for Fair Admissions, right? We're not considering race as a factor in college admissions. Everyone it's race blind, right? That's the idea. And so the standard is going to be the same whether you're in the majority or minority group. Second case is the Duval case in the Fourth Circuit, which is our circuit. And so this is binding precedent for us. And in that case, it was a white executive who said that he was ultimately moved out of his job because the company had DEI efforts, including quotas, where they were trying to get 3 to 4% of their executive team to be from a racial minority. This is a pretty common thing that existed prior to 2023 is companies with these diversity goals in their executive ranks. And this individual was terminated, and the court held, yeah, that is a Title VII violation. So if you have any kind of quota or where there's going to be a decision point around a person's race or gender, that's going to be a problem. And I think that, isn't really a gray area at this point. So if we go to the next slide. But what is more of a gray area is around our DEI programs that aren't about a particular hiring or promotion practice and how that's playing out. So I've got 4 cases here that deal with DEI training and hostile environment. And what that means is people come forward and say, because I was required to attend an equity training or a diversity training of some kind, professional development, I was subjected to a hostile work environment based on my race. So we see claims about people kept talking about white privilege and the obligations of white people to address issues of race, and therefore in this training, and therefore I was subjected to a hostile environment based on my race. That's the claim. That's the claim people have brought under these cases. And we have, you know, this isn't something that's really been litigated in our area, but the courts have gone different ways around the country. We've got Ohio and Pennsylvania going in opposite directions. In one case, finding that the training did create a hostile environment, and then the other, the court finding, you know what, this training was, the plaintiff didn't articulate exactly why the training was such a problem that a hostile environment was created. And then we have Washington and New York City going in different directions with municipal programs that both required employees to participate in training. And the court finding in one case that it created a hostile environment and in another case it didn't. There's some different factors here that if you do have DEI training programs, I do think that it's worth a look to see how you're structuring those, how you're describing those, whether they're actually creating an inclusive working culture or an exclusive one, and in particular, whether they are mandatory or voluntary programs, because all those factors kind of played out differently in these different cases. But I did want to kind of highlight for you all that the courts are struggling with this concept. It is not simply that you can continue DEI training without taking a look at it. There's certainly a concern there. And the executive order sort of re-emphasized that concern that they could lead to an argument that someone is in a hostile work environment. The other big question we get, if you go to the next slide, is around affinity groups. So a lot of these groups started in 2020. Some of them existed before. Can we have in our workplace a group really of support for a particular race or gender? And these executive orders suggest no. This one case that's really dealt with this has said, if it's a voluntary group, then, what is the harm? You'd have to kind of go through a lot of steps to say that you were harmed by people who voluntarily participated in a group, and especially if the group is open to all. So affinity groups, however, there's another argument here, right? That people could say, well, you made everyone go to a particular group and then you were segregating an employee benefit based on race, and therefore that's a problem. So we haven't had a ton of litigation in that, but I did want to highlight that for you all that, you could look at a hostile environment claim coming out of an affinity group situation. So it's just something else to look at within your DEI program. So we'll just end this part of the presentation with some do's and don'ts. If you haven't already, what we've seen in 2025 is a surge in the federal administration's focus on diversity, equity, and inclusion and reverse discrimination issues. And so it is worth revisiting what you are doing in that space. You still have an obligation under Title VII to ensure that you have a supportive work environment for everyone. And so whether you call that DEI or you call it something else to promote inclusivity, you need to be looking at it and making sure that there aren't specific parts of your program that could create a hostile environment, whether that's the training and how it's structured, whether it's mandatory or voluntary, whether you have specific diversity goals. In terms of hiring, that's another area where you should be reviewing that. Looking at affinity groups, looking at your contracts with third parties to make sure that you aren't incurring additional liability with them. in terms of how their DEI program might operate. So those are do's, just some proactive things that you can do. In terms of don'ts, I think some of this is a little bit obvious. Don't discriminate on the basis of race. And so whether it's selecting a person, um, or promoting a person or terminating a person, it should never be because of their race. Whether that's because you have an effort to increase the diversity of your staff, or because you think that people from a particular race fit well into a particular role. Um, there's just not going to be any space to do that. And so if you've got those types of programs in place, I do encourage you to seek legal counsel to um, address those.
Right. Thank you, Elizabeth, and
Sure.
thank you, Lauren. Um, that takes us now to looking at some EEOC enforcement priorities. What is the EEOC? Where is their attention? Because that might help us understand what we need to be most mindful of. So we've got three of us here to cover this one, and I'll hand it off to Vanessa to kick us off.
Thanks, Brian. My name is Vanessa Canuto, and I, along with Jesse Ballamoran and Brian, will be discussing the EEOC's recent enforcement priorities. We can go to the next slide. And first, we are going to discuss the newly appointed EEOC chair, which is Ms. Lucas, and her stated priorities. She has stated that she is committed to enforcing the law even-handedly, advancing equal opportunity, and upholding merit-based colorblind equality in America's workplaces. Specifically, the EEOC is committed to dismantling identity politics that have plagued the employment civil rights laws by dispelling the notion that only the right sort of plaintiff is protected by Title VII. And Ms. Lucas has explained that what she means by this is that employment civil rights are a matter of individual rights, and she draws an emphasis on rejecting identity politics. What she means is that justice being measured by group outcomes, and that civil rights exist solely to remedy harm against certain groups of people. And to combat this, her enforcement priorities have now become rooting out unlawful DEI motivated race and sex discrimination, protecting American workers from anti-American and national origin discrimination, also defending the biological and binary reality of sex, protecting workers from religious bias and harassment, and also just remedying other areas of recent under enforcement, which now Jesse will expand upon what those enforcement priorities now are.
Thanks, Vanessa. So I'm guessing most or all of you know the role the EEOC plays in employment law in the workplace, but the EEOC is almost always the first stop for somebody who is thinking about bringing a claim against a company. And that happens in a couple of different ways. They either file a charge with the EEOC as a required step before they go into federal court, or the EEOC is doing its own investigation inside of a workplace. And in the meantime, the EEOC is putting out different forms of guidance and kind of signals to employers about where it's going to allocate its resources, what it views as its responsibilities under the law. I've heard it said before, like, it only matters so much what the speed limit says on the sign. What matters is what the police officer thinks the speed limit is. And so this section, we're going to just walk through what the speed limit is according to the signals we've gotten in 2025. You could go to the next slide, please. So there has been an inversion of priorities, as Vanessa was just speaking to. Some of the things that we've seen historically as EEOC priorities are explicitly no longer on their radar at all in some cases. Disparate impact claims are a good example. So Title VII contemplates a legal claim in which a policy may be facially neutral, but has the impact of excluding one group of people based on a protected characteristic. So you may not have a policy saying we only hire workers of a certain gender, but if in practice only one gender is hired, that would historically have been considered a disparate impact claim. Race discrimination in the traditional sense is also no longer an enforcement priority, and then sexual orientation, LGBTQ rights are off the table. We are seeing an uptick in enforcement for religious practices, disability accommodation, age, and pregnancy. Brian, if you can move to the next slide, please. Thanks. So religious discrimination, we've seen a lot of activity here this year, and we've seen press releases, we've seen public statements. They have made very clear that one of their goals of this administration is to use the EEOC's enforcement powers um, to increase attention and protection for religious practices at work. We're seeing this in a couple of different ways. One is we're still seeing ongoing investigation and litigation around these vaccine mandates from during the COVID era. So if you were working with us at the time and we were working through, vaccine rollout and reopening the workplaces, and you think about how far removed we are in 2025, there's now a sort of retroactive lens being applied to some of these requests for religious exemptions and the protections that people have or don't have because of their religious beliefs. Religious accommodations is another big area. So things ranging from uniform modifications to accommodate somebody's religious practices, observing the Sabbath. In some cases, some of that anti-harassment training that was touched on in the first part of our presentation can touch on religious protections as well. If an employee feels like the harassment training provided by their employer infringed upon their religious beliefs with regard to things like a trans employee in the workplace. And then they've also highlighted a priority on anti-Semitism, particularly in the university space, and what they're calling anti-Christian bias. They issued this press release in August. So this is an example of, it's not just what we're seeing from them in the courts and in conciliation efforts, we're actually seeing this as an affirmative announcement. Next page. Thanks. Disability discrimination, a lot of this is the same song and dance we've seen for a couple of years, but is getting some special attention under this EEOC. Remote work continues to be an issue. So I know that's the bane of a lot of HR managers' existence, but remote work is still on the table as something that needs to be discussed. Medical accommodations in general. So if you're not up to speed on the interactive process, if your immediate supervisors and mid-level managers are not, it would be a good time to sort of refresh them on that. And then leave as an accommodation. So leave can be available to employees under a couple of different laws and different workplace policies. The important thing to remember here is that the ADA specifically recognizes that leave can be a form of a reasonable accommodation in certain situations. So if you have an employee who has a medical reason that they are struggling to perform their job duties, they ask for time off, we recommend checking with counsel before you make a decision to grant or deny that leave, because that could have ADA implications. Next slide, please. Age discrimination has also resurfaced. You can see that in everything from hiring and promotion opportunities to workplace technology. That might be as simple as comments about what somebody is perceived to be able to do or not do, and then reductions in force, who gets selected to be let go and who does not. And then pregnancy accommodation, you probably remember that the Pregnant Workers Fairness Act was passed a few years ago. There was some lingering litigation around whether that law had been passed in a way that it should stay on the books. We got a final decision on that point earlier this year. So pregnant employees have rights that are very similar to disability rights under the ADA, and things like modified duties and leave are on the table. And then again, they are going pencils down on enforcement for some of the more traditional EEOC areas of priority, disparate impact, again, being one of them. Race discrimination, we are seeing, excuse me, we are seeing an uptick in so-called reverse discrimination claims, but not so much the traditional sorts of race discrimination that you would expect to see through the EEOC. And then sexual orientation, LGBTQ+. I'll also add that we're seeing some renewed focus on retaliation as an avenue to bring claims. So that's sort of lingering out there as a category separate from these protected characteristics. And with that, I will turn it to Brian. Oh no, to Vanessa.
Thank you. Now we're going to talk about 3 recently publicized EEOC settlements. The first one will be regarding disability discrimination. So there was a $200,000 settlement with a residential property management company that was charged with 3 different things. The first was retaliating against a manager for taking a medical leave of absence, as she was placed on a performance improvement plan the day that she returned from leave. This manager was also punished for a decline in her occupancy rates at her properties while on leave. And this company was also prohibiting employees from returning from medical leave without a full duty release note. And the EEOC stated that these practices prohibited disabled employees from returning to work if they needed an accommodation. Next slide. The next one will be age discrimination. And this was a $1.8 million settlement with Enterprise Leasing that was charged with failing to hire candidates 40 or older for its management trainee positions between 2019 and 2025. Even though approximately 15% of the applicants were 40 or older, these applicants were less than 3% of all hires. And there were actually over 100 witnesses that had stated they were asked their age, their graduation year, and other age-related comments during their interview process. And then the last settlement we're going to talk about is a religious discrimination one. And this was for $61,000 for a North Carolina-based dental company that was charged with failing to provide an employee with a religious accommodation, as it fired this employee after she requested to wear a scrub skirt instead of scrub pants due to her sincerely held religious beliefs. And now Brian will actually talk about further current EEOC litigation.
Thanks, Vanessa. So just like those settlements are a nice little indicia of reading the tea leaves, what the EEOC says, what they settle, and then what they sue over are all really great data points to help us learn where they're kind of shining their attention and their efforts. So just a couple of quick cases we want to share with you. And these are kind of hot off the press, by which I mean they've just been filed in the last month or two. And so we've dug into those and learned what the particular allegations are. And they kind of corroborate what you've heard already in terms of priorities. So the first one is a disability discrimination claim that the EEOC filed against Coca-Cola. So just to level set, the EEOC, any individual plaintiff or group of plaintiff employees can bring a lawsuit on behalf of themselves if they have a legal claim for discrimination or whatever. But after they go through the EEOC process, the EEOC can effectively choose to bring claims on that person's behalf or on a group of people's behalf if it's a group style of claim. And so each of the four cases I'm going to talk about just quickly are examples of where the EEOC has decided it was going to pick up the mantle on behalf of an employee and bring a lawsuit against the employer. So this first one against Coca-Cola, there was an employee who had renal disease. He needed regular dialysis. And so he asked for an accommodation just to shift his schedule to get that treatment. He's a delivery driver, right? Delivering product to restaurants or groceries or whatever. He struggles to get that accommodation. And frankly, as I read the complaint, it's not that aggressive of an accommodation request. Another thing that's the EEOC puts in the complaint that I think is very noteworthy and a concern I see more than I wished I did is the employer had a policy of terminating people after they'd been out on 6 months of leave, and his initial disease required him to be out for an extended period of leave. He was ready to come back. He asked for a change in his work schedule. He even identified a position that was open that would have fit his schedule, which can be a reasonable accommodation. And the answer was no across the board. And so the EEOC has sued on his behalf. The only thing I want to say about this, and it's true for all these cases, if hopefully none of you have ever been through the EEOC process. Of course, folks on our end of this webinar have been through it a bunch. And if the EEOC makes a finding at the end of an investigation, that's sort of their way of signaling that they believe that something has happened that's unlawful. Sometimes they then they can just issue a right to sue, giving the employee sort of permission or the last checkbox they need to hit before they can go file their own lawsuit. Sometimes the EEOC will enter into what's called the conciliation process. That's when the EEOC starts to move from being an investigative body to sort of an adversarial body with the employer. And in each of these four cases, the EEOC tried to go through conciliation, which is like an aggressive negotiation to resolve the case before they go to mediation. Before they go to litigation. The point really here is that if the EEOC starts moving towards conciliation and you get a notice that it's time to have a conciliation, I think the right way to construe that is if we don't solve this now, they're ready to go litigate over it. So that's that case. Another age discrimination case out of Colorado. And this was actually a group of employees, multiple nurses who were age 60 and over. Again, a failed conciliation, but the allegations included that staff leadership said they needed more young, youthful, and energetic nurses. And then a nurse complained, a nurse within the group, so in her 50s, complained about being treated differently for being older than apparently what was desired. Um, and then one of the quotes that's in the complaint is that an HR director said, "Someone went to HR and I'm going to find out who." Well, now we've got a discrimination case on top of a retaliation case. That's if I could write a quote that sounds like retaliation, that might be the one. Um, then we've got out of Virginia at an Apple store up in Reston, up in Northern Virginia, a Jewish employee who asked for and for a good period of time received days off for the Sabbath to observe the Sabbath. He asked for Rosh Hashanah and Yom Kippur off. First, he was told no, then he was told yes. And when he was told yes, he was also told, well, I guess this explains why you have a beard. He was told right after the Hamas attack on Israel that he was not allowed to talk about that issue in the workplace. And then he repeatedly had to sort of fight an uphill battle to get Fridays and Saturdays off to observe the Sabbath. And ultimately, he was terminated. Again, this is an individual employee claim that the EEOC picked up on, I think, further kind of corroborating their priorities. And then a case out of Delta Airlines out of New York. This is a pregnancy discrimination case in which a woman applied for a position as a gate agent at LaGuardia. Delta has a policy requiring that applicants pass a physical ability test before they can, which you can do, but they under certain circumstances. But they also had the ability of the applicant to give, if they were concerned about that test, to get a waiver or a confirmation from a treating physician that that employee, in fact, it was okay to put that person through the physical ability test. This woman got that waiver from her treating physician, went to the third party company that Delta uses to do the assessments, and they looked at her and said, "I'm sorry, you're pregnant. You can't go through this process." And to which she said, "But here's my waiver." And they said no. She went back to Delta and they said, "Okay, we'll clear this up. Yeah, that's a misunderstanding." But then Delta, for at least as alleged, again, these are all allegations and complaints. Um, Delta doubled down and said, "Yeah, you can't go through that process. You cannot take the physical ability test." And so again, there's EEOC jumping in after a failed conciliation and picking up an individual plaintiff case. And then finally, here's another one that just happened in North Carolina, just down east. Um, Smithfield Meats hired a woman, a pregnant woman, to be a general laborer. She was hired on August the 7th of 2023. She disclosed she was pregnant when during the application process. She had a workplace incident. It's not really clear what that incident was. She requested light duty for 2 weeks from her treating physician and was told she needed to come back to work with no restrictions, which is another sort of foot fault I see more than I wished I did from employers. And then when she didn't come back with no restrictions, she was fired 6 weeks after she'd been hired. That is an easy one from a something probably didn't go right here situation. So in each of these are just continued examples of where the EEOC is putting its resources. And we do have a question I wanted to lob to Jesse if I can. We've got a question about accommodations. And the question is having no childcare an accommodation you need to meet, specifically letting them work from home? I take that to mean if an employee says, "I cannot come to work because I don't have care for my child," is that something an employer has to accommodate?
Yeah, that's a good question, Brian. And I think, the lawyer's favorite answer is it depends, but this one is a most likely no. So the accommodation piece that we were discussing earlier for remote work applies to somebody who is in a protected category. And that could mean they have a disability that limits their ability to come into work and do their job. It could mean they are pregnant and are having a hard time coming in to do their job. Having a child and not having childcare is not covered by any of the laws we're talking about today. So there is not a legal requirement to provide remote work, and many employers will have a policy that says remote work is not a substitute for childcare, just to avoid that confusion on the back end. Now, I will say where some employers can walk themselves into a little bit of a tricky spot is if they are flexible with remote work for other life obligations. So, caring for an elderly parent, caring for a pet, attending to something at your house. If the person who has a child is reporting to work and sufficiently attentive at work, and you have sort of looked the other way when people who are not maybe of the same gender have to do things for out of work purposes, you could create a situation where it looks like you are treating someone differently, say because of their gender, even if from management's perspective, the difference is having, a 3-year-old at home versus not.
Great. Thank you. Thank you, Jesse. So now we're going to turn to chapter 3 of today's time together, which is about employee misclassification issues. And I'm going to turn it over to Tricia Kemper and Aaron.
Thank you, Brian. Good afternoon, everyone. I'm Kemper Pat, and I'm happy to be here with everyone this afternoon. As Brian mentioned, we're going to finish this afternoon talking about some updates in employee misclassification issues. There's 3 main topics we're going to discuss. First, I'll be discussing the FLSA exemption analysis and the recent Department of Labor overtime rule. And Brian, you can go to the next slide as well. Aaron, after that, we'll discuss updates with the independent contractor versus employee analysis. And then Tricia Goodson is going to finish us with some recent developments in case law concerning employee misclassification issues. You can go to the next slide, Brian. So when we're talking about FLSA exemptions, the FLSA, that's the federal wage and hour law that it places a variety of obligations on the employers that it covers, one of which is that employers have to pay non-exempt employees overtime. And so naturally, a question we get quite often is this employee FLSA exempt? And you can go to the next slide, Brian. The default rule under the FLSA is that employees are not exempt, meaning that they are eligible for overtime pay. Now, when an employee is eligible for overtime pay, they have to be paid 1.5 times their regular hourly wages for all hours worked over 40 hours in a work week. And now, the important thing to keep in mind here, I think, is that simply being salaried does not make an employee exempt from the FLSA. It's just one aspect of a broader analysis to determine whether or not an employee is exempt pursuant to some of the typical exemptions that we see under the FLSA. So, in that regard, what are the requirements for an exemption under the FLSA? Well, it depends, right? It depends on the exemption. The exemptions that we see most often and are most often used, these white collar exemptions, these would be your executive employee, the administrative employee, the professional employee, the exemption for highly compensated employees. These are what we see and are used most often. Under these exemptions, the employee has to meet 3 tests to be considered exempt. The first one is they have to be paid on a salary basis. So this means that the employee is paid a predetermined amount on a weekly or less frequent basis without any changes based on quality or quantity of work. The second test, the salary level test, this is requires that the employee's salary has to meet a certain weekly threshold. We'll talk more about that here in just a moment. But the third test is the duties test, right? So the employee's primary job duties have to meet certain criteria, and that's going to depend on which exemption they're classified in, right? So if they're classified, if you're trying to determine if they're classified as an administrative employee, they will have to meet certain job duties, whereas if they're, say, an executive employee, there may be some different job duties they have to meet. Next slide. So, we're talking right now about our year in review, and you might ask, well, what is going on recently that I have to know with regard to FLSA exemptions? So, as I mentioned, one of the three tests necessary to determine if an employee is exempt under these exemptions we've been referring to is the salary level test, right? The employee has to have a salary meeting a minimum weekly threshold. In 2024, the DOL actually finalized a rule that would raise the salary level required to be exempt for these exemptions that we've been discussing. And you can see them here. We're limited on time, so I won't go through all of them, but you can see that what the salary level was prior to this rule and what this rule sought to increase them to it was a substantial increase, right? And it could increase even more as years went on. And so the big takeaway here was with this finalized rule, many employees would no longer be exempt under the FLSA because while they might meet the salary basis test and the duties test, they may no longer be paid at the appropriate salary level to be exempt under the FLSA. So you might ask, well, what ended up happening with this rule? Well, in November of 2024, a Texas court vacated this new overtime rule and basically prohibited the Department of Labor from enforcing it on the grounds that the Department of Labor did not have the authority to implement this new overtime rule. The Department of Labor did appeal it, but in early 2025, once the new administration came in, that appeal was stayed, so it was effectively paused while the new Department of Labor would reconsider this rule. And since then, there really hasn't been a notable update in that regard. And so for now, we are really back to what the salary level test was prior to this final rule. Um, and as like I mentioned, you can see here that's at $684 dollars per week for the executive, administrative, and professional exemptions, and $107,000 and 400 or 107 $432,000 per year for the highly compensated employee exemption. Now, despite that, this appeal seems just now to be on hold. And there's really no further action in this regard. It's still, I think, prudent for employers to stay vigilant and keep an eye out on this appeal in case there is any movement or anything like that, or if this rule is revived in some fashion. And I'll finish before handing it over to Aaron for a very quick hypothetical. Um, let's say Sally is employed by ABC Co. as a sales manager. Sally is paid a salary of $2,000 biweekly, a total of $52,000 per year. Is Sally exempt? And I will let everybody, our wonderful audience, lock in their answers at home. And the answer is, well, it depends. We don't know, right? It seems Sally is paid on a salary basis and meets the salary level, but we don't know Sally's job duties, so we can't determine that last step of that test to figure out if Sally's exempt. So it's a bit of a trick question there, but for now, I will hand it over to Aaron to talk about employee classification issues with regard to contractors versus employees.
Thanks, Kemper. So in 2024, there was a new independent contract rule that was put in place by the DOL. It was considered an employee-friendly rule, which meant that the factors that were weighed under that rule made it more difficult to classify someone as an independent contractor. Again, that's the DOL. So the IRS has its own rule that we're not taking a look at today. But as far as the DOL goes, there was a rule put in place in 2024 that was very employee friendly and not very friendly to independent contractor classifications. Next slide, please. This year, the DOL Wage and Hour Division issued a field assistance bulletin to its investigators. So this was a sort of internal but publicized guidance to investigators on what they should be enforcing as far as independent contractor classification enforcement actions went.
investigators were directed to not apply that 2024 rule. So the DOL indicated that it would reconsider that rule that was employee friendly and directed its investigators to not apply that rule in current enforcement actions. Next slide, please. So instead of applying this new 2024 rule, investigators are directed to go back to the prior fact sheets and opinion letters that had been issued before the 2024 rule and use those to determine whether someone was properly classified as an independent contractor. Next slide, please. So under those resources, we are back to the old factors that you might be familiar with. We're looking at control, the permanency of the relationship, so how long it lasts, who's investing in facilities and equipment, how much skill, initiative, judgment, or foresight is required, whether the worker has opportunities for profit or loss. So, an independent contractor, especially one that is operating as its own business, will have more opportunities for profit or loss than an employee whose opportunity for profit just depends on how many hours they work, as well as the extent of integration of the worker's services into the business. And throughout all of these woven in is the degree of independent organization and operation. Next slide, please. So overall, it's still a case-by-case analysis. It's still a factors analysis. Control is still the key factor, but we're sort of back to a more balanced test that may not be quite as employee friendly and may make it a little easier for employers or companies to classify workers as independent contractors. I will note that there is still no such thing as a 1099 employee. So as you're talking about your workers and your classifications, we have employees and we have independent contractors or 1099 contractors. But once you start using terminology like 1099 employee, it raises a red flag. And also just note that the 2024 rule is still being used in private litigation, so you may still see it come up in cases where individuals have brought misclassification claims, and we're watching to see what happens with those. Next slide, please. So Tricia is going to give a quick update on some case law and enforcement developments based on worker misclassification.
Hi, everyone. I'm Tricia Goodson. And so, yes, I'm going to talk about quickly because I think we're running close to the end of time. But kind of these next 3 slides are just kind of the why does it matter? Why are we talking about these things for misclassification? It's because it's costly. Here's an example that in June of this year, the Department of Labor recovered $101,000 and change in back wages and damages owed to just 31 employees. So what the employer had done is they had paid the employees a salary, but failed to pay them overtime premiums for working in excess of 40 hours. So what it means is that the employer, it kind of goes back to that point where they were merely paying salary and thought that exempted the employees from overtime. And you have to, that is only one aspect. You have to make sure, as Kemper talked about it, that they're meeting the other tests as well. So again, we do hear from clients from time to time, oh, but we pay that person a salary. And just know that that is not the end of the analysis. It is just the beginning. So here's an example. That is just an example of how it can be costly. Next slide is a case here in the Fourth Circuit that it gave a $9 million. Brian, if you could go to the next slide, that'd be great. Oh, got it. $9 million judgment against medical staffing company brought by the Department of Labor. Again, it was 1,110 nurses and nursing assistants that were misclassified as independent contractors. The court did go through the steps that were talked about earlier, looking at degree of control and skills used, etc. And they walked through the analysis of those factors and found that the employer was controlled the schedule, the communication method, compensation. They provided performance reviews and disciplined workers, and all of that weighed for an employment relationship. And unfortunately for this entity, all the other factors weighed in favor of the nurses and nursing assistants being employees as well. And so they were found to be in violation of the law to a very costly $9 million. And then the last one is this was in California, and it was California state law. Just a reminder that your state Department of Labor's may have some different analysis, but here's another example where $10 million judgment against an employer. Again, it was over misclassification. So it is expensive to not to review it on the front end. Might help you out in the long run because it is very expensive to do it wrong. And so just to recap, next slide, please. There are red flags for the Department of Labor and wage and hour. So if you kind of hit one of these, you might want to think about, maybe we need to look at this. If no employees are classified as non-exempt in your company, that would be a red flag to the Department of Labor. If exempt employees are ever paid hourly, if there's a lot of deductions or up and downs in an exempt employee's wages, all salaried employees are classified as exempt. That's another red flag. If there's no weekly timekeeping records, inside sales that are being treated as exempt. Assistant managers are also an area where it is oftentimes incorrectly classified as exempt. IT roles are another huge trigger for getting it wrong, unfortunately. And then all employees in HR and admin roles, when they're classified as exempt, that's also a red flag. So, and as Kemper and Aaron mentioned, if there is no such thing as a 1099 employee. And if you say, oh, but they're salaried, if that's your reasoning why they're not getting overtime, that's another red flag that you should look at your policies and make sure you've analyzed if they are properly classified. So looking ahead, I would audit your current exempt, non-exempt classifications, review and evaluate your current independent contractor relationships and agreements, and keep an eye on the legal developments.
Tricia, thank you. Thank you, all of you.